The following program is a Town of Colonie television production of the William K. Sanford Town Library.
Hello, I'm Colonie Town Judge Peter Crummey, and welcome to Benchmark. We'll explore a variety of issues involving our legal system, our justice system, and how they intersect with the citizens of the town of Colonie. Today, we are truly fortunate to have as our guest Albany County Attorney Tom Marcelle. And Tom, welcome, and thank you for joining us today.
Judge, thank you for having me. This is great.
You know, Tom, you are involved in so many different legal issues on behalf of the county. It's a major corporation, Albany County, and you are the legal wizard for the entire county and have done a marvelous job in a variety of different ways. You started service as our Albany County attorney in 2012. But as many of our viewers know, you have a long line of community involvement and legal involvement, which has brought you not only locally here in the capital region, but all the way down to Washington, D.C., where you have practiced before the highest court in the country, the United States Supreme Court. So sadly, a half hour today won't do justice to the background and experience of Tom Marcelle, but we're thrilled you could cut away a little time for us today. Tom, tell us now about your county attorney duties and the office of the Albany County attorney.
Sure. You know, Judge, as you mentioned, it's a $500 million corporation with 3,000 employees, and we do everything. We're charged under law to prosecute juvenile delinquents. If there's a problem with where your parents are being abusive to children, we have to represent the child and protect them. If there is someone who's mentally incompetent, we've got to get help for them. If the sheriff's office in jail is accused of mistreating a prisoner, we defend them in federal court. Every time there's a car accident in the county, a contract, we do it all. And it's a big undertaking. We have about 19 lawyers and a staff of 32 in the county, and they are really hardworking. They're dedicated to public service, and it's, I tell you, been a fantastic job and fantastic experience.
Well, Tom, you're in a long line of notable attorneys who have served as our Albany County attorney, and of course, John Klein and our own Sue Tatro back in the 90s, and Michael Lynch as well, all served as county attorney. You bring a dynamic which is unparalleled, in my opinion, into the position, and that is your litigation experience, not only in our state court systems, but of course, as we've said, even in our national court systems, federal systems as well. And that's allowed you to take some action in how to reconfigure the county attorney's office as well. And tell us what you're doing today at 112 State with your office.
Sure. I mean, one of the big issues when County Executive McCoy was elected was the county attorney's office basically had outside counsel do all the civil litigation, and it cost taxpayers somewhere between $350,000 and $400,000. Well, for better or for worse, the county exec told me, well, Tom, you're a litigator. Why don't you do all this $400,000 of cases? And well, we've taken it under. We've hired some really terrific young attorneys. We have some veteran attorneys, and we've reduced that amount. This year, we'll pay approximately $35,000 in outside counsel fee. So we've reduced it by a factor of 10, and I've got to tell you, it's, Judge, the young men and women who have stepped up and have taken cases and tried cases. In fact, we did last year for a sheriff's deputy who was accused of beating a prisoner. We went to a jury verdict in federal district court, and the jury came back and found the deputy not responsible and not liable. And I got to tell you, as far as we can research, it's one of the few, if ever, we think the first one ever that the county attorney's office itself has taken a verdict in federal district court.
I have to believe, and having served in county government myself for 8 years as a county legislator, that to recognize how county government works, I have to believe there's few counties in the state of New York that actually the county attorney staff is in charge and in actually prosecuting and moving forward on litigation at all levels. It's rare indeed.
It's rare. It's tough, right? Because you were in the legislature, and a lot of the county attorney's work is helping the legislature craft the laws and resolutions and advise them on the legality of their actions. And so, your primary focus is to keep the corporation, its officers, and its legislators on the straight and narrow. And there is always a terrific cast of characters who get elected, and by the way, a good thing. They push the envelope. They want change, but anytime you have change, you have to do it within the constraints of state law, and you remember where you are on the totem pole, and. So that keeps us real busy. So undertaking this was a real project, but again, it was great to see the lawyers in the office step up.
Well, Tom, you've certainly every day there's media reference to activities taking place at the county level, and your office is certainly an integral part of those issues. I recently, just last week, I noticed that there's a pending case right now on redistricting, which is in the federal court system, and you are once again involved in representing and defending the county in its mapping of the districts. And of course, I remember back in 1991 when I first ran for county legislature, it also was challenged, and lines were redrawn somewhat, and we all had to run again in 1992. But certainly these are big issues. What's happening in this current case right now?
Sure, that's a great case. And look, this is a case that affects everyone because they vote on these districts. It's who represents them. And look, what happened was back in 2011 when the maps were redrawn, some of the folks in the minority community said, hey, we want another district. We think there's sufficient population to have another district, especially if you combine blacks with Hispanics. And it's a real legal question of whether you can combine two races and treat them if they are a single race. It's a question the U.S. Supreme Court's left open. Our court that oversees us here in New York is called the Second Circuit, and that court said, hey, that's an unclear question. We don't know what we're going to do on it. So far, we've been very good. We've prevailed at the trial level on preliminary matters, and in the Second Circuit on preliminary matters. But I think there's one important aspect of that case. And what voting rights talks about is the ability of minorities to elect candidates. And Albany County has a stellar record. The district attorney of Albany County is an African American who actually be a white incumbent from a dynastic political family. You have the president of the Albany Common Council in a city that's 75% white is an African-American woman. We have elected coroners, and in the county legislature we have a white woman from a predominantly African-American district. We have an African-American male from a predominantly white district. 3 out of 7 members of the school board are African-American in the city of Albany, and there's this rich ability of African-American candidates to win in white districts. And I think really to suggest that the people of Albany County are somehow racist or they vote on skin color is belied by how the people have actually voted. In fact, twice overwhelmingly the people of Albany County supported Barack Obama for President of the United States by 2-to-1 margins. So I think at the end of the day, this redistricting case, I don't think will yield much. I always think it's better to try to settle a case. I mean, as a judge, you see it all the time.
You bet.
We're at the point now where we're opening statements, getting evidence, and I hold out the hope that everyone can resolve their differences, because it's always better when especially in political type cases, when people can come to a consensus. And I certainly would like that. I certainly hold out hope that we all can agree on a set of districts that would make everyone happy.
Well, and I routinely remind litigants in my own court that if you can settle this matter, you certainly had, you could control how that went. Once you ask a judge to do it, you have no idea what that judge is going to do at the end of the day, or what will be received by the judge in order to make a decision. And if you can settle it yourself, you have a much stronger position in an outcome. Because you just don't, once it's surrendered to a court, you just don't control that anymore.
That's right. And, you know, you're always better off, as you just said very wisely, Judge, that if you can reach the consensus agreement to control. And look, judges, as you know, like you said, have limited ability to receive evidence. They may not know the totality of the circumstances. It may not come in. And judges certainly have their own point of view on things. And there's a big risk that they may not get the picture because, I mean, you know, you see it all the time. Witnesses on a witness stand is a very intimidating thing. And what they say to lawyers in private in the comfort of a conference table doesn't always come out that way when they have to raise their hand on a Bible and see a judge in a black robe right there. They get nervous, they don't communicate as well, and therefore the judge sometimes has inferior knowledge. But that's a big risk at trial.
Always. I agree. So we'll stay tuned on that particular pending matter. But you've accomplished so many other things as a county attorney too, and not only consolidating the legal practice for the county of Albany, but you've brought something unusual that we at the Albany County Bar Association have wrestled with for years, and I currently serve with the county bar, and we've recognized that our 1,400 members are essentially private practitioners. And we all recognize the presence that government attorneys have in Albany County, not only at the county level, but certainly at the state level as well. And we often try to create programs to encourage membership from government lawyers as well. And over the years, there's been some success, but limited in many ways too. But you're the first one to actually create an environment that actually has government attorneys and the Albany County Bar Association working together and generating this image that a bar association represents all lawyers, and you've done that for us, and thank you.
Well, you know, first of all, you say you're involved. We might as well say you're the president of the association, and I got to tell you, you've just served in a wonderful capacity. You've opened doors and channels of communications, I think, that have followed for way too long. And one of the things, we have an opportunity to meet and discuss the ability of the county to work with the County Bar Association. And I got to tell you, it was fantastic working with you on this. We've had a number of projects, and certainly one I like to highlight, and I'll talk a little bit about some of the other things, but one I like to highlight is last year, with the help of the Bar Association, we put on a program for juvenile delinquents for a bunch of counties. It was sponsored by the Albany County Bar Association, and 47 different counties from around the state, from as far away as Niagara County, came to Albany, came together under that umbrella to hear a CLA sponsored by the County Bar Association. And from there, we leveraged a lot of different things. You know, look, private practice and government practice are really different. You face different burdens. A lot of times we oppose each other. But one of the great things that through the Bar Association and your leadership we're doing is the county's becoming a sponsor of some continued legal education. And through that, as we go through our litigation, and from our perspective, it's not only interesting in getting other government attorneys, and again, look, Albany's a government town, right. We're infested with government lawyers, and so to reach out to our brethren in the state and the municipalities and have them come in and not feel because they work for the state comptroller or the attorney general that somehow they can't be part of the Albany legal community is groundbreaking. And really, what you've done in that regard and what you've conceived here, I think is going to it's going to flourish. And right now we're in a stage of germination, but I can see the vision. I think it's going to have a dramatic impact going forward.
Well, it's only can occur by you shepherding this in the capacity that you can, and I think that the future of lawyers in Albany County and having an association representing all interests. It can only happen because of what you've started here at the county level, and we're thrilled to enjoy common CLEs or continuing legal education programs with your staff. Your staffers alone are capable of teaching on a variety of subjects which benefit all members of the county bar, and we continue to learn from your staff as well. And as you said, other counties have recognized this, Albany County, as a mecca for a variety of these legal programs. And I thank you for being part of making sure that this continues to go forward. Thank you, Tom. Yeah. It's great for all of us.
Yeah, well, Albany's, before we went on, we shared a little story about a case I litigated against a New York City law firm. And lawyers certainly have this reputation of being soulless and all these evil connotations. And in some places it's probably true, but I tell you it's not true in Albany. And one of the great things I have found is in the county, we generally have a collegial respect among the attorneys. Our kids go to school together. They play Little League together. They're in plays together. And you can only be so obstreperous when you have a relationship with someone. And one of the great ways we all build relationships is through the bar, but it's so much more. And as people in Albany County and in the town think about their legal community, that they should take, I think, a certain degree of pride. We have outstanding practitioners, but I think generally you don't see these stories in the paper or on the TV about attorneys just bizarre antisocial behavior. I think the people of our community should be proud of their bar.
Well, and I know that typically residents, sometimes residents in general can think that, take certain positions about attorneys in general, but their own attorney or their next door neighbor, that is one, they recognize them as good neighbors, good parents, and good community leaders as well. And that's something that, in the end, that's what the citizens recognize in the end, and to look at it in general sometimes may not appear to be the most flattering, but actually when people recognize that they do like their own attorney and they do like the community service that so many attorneys provide on a daily basis. When you think of all the not-for-profit corporations that attorneys serve on and give of themselves in a pro bono atmosphere, routinely giving back to the community in a variety of settings. The attorneys are an integral part of a civilization, and one that's progressive, and one that takes care of those who need help.
Yes.
And your staff does the same thing routinely in a variety of different ways, and certainly in the collaborative efforts it's making with the County Bar Association. Tom, your resume is chock full of cases that you've taken on and spearheaded all the way up to the Supreme Court. And one that I know that is notable, certainly to the residents here in the area, is the case that you took on representing a SUNY student, I think a U-Albany student, if I'm not mistaken. And the case was against, it was challenging the requirement that that student have to automatically contribute $5 for membership in a certain student group even if they did not want to join that student group. Tell us about that case.
Sure, it's a great case and very fascinating. There's this big organization. It's a political service organization, for lack of a better term, that every SUNY student in Albany, in Buffalo, in Plattsburgh was required to pay $5 each semester to support. And this group would take the money, they go out, they would lobby the legislature, they would pass petitions on issue. Well, there were a bunch of students, for lack of a better political term, were more conservative than the group's ideals. And they began to question, well, why should I pay my money to an organization who I don't agree with politically? I don't think I should have to do that. So through actually one of the political chairmen, they got a hold of me, and we said, and I looked at their case, and I said, you're right. You don't have to support speech you disagree with. It. There's a very famous case in the Supreme Court from the 1940s, a Pledge of Allegiance case, where Jehovah's Witness didn't want to say the Pledge of Allegiance. The Supreme Court said the government can't force you to engage in speech you don't want to. And that was our argument here. You're forcing these students to engage in speech that they do not wish to. Well, a long story short, they brought in a big law firm, 500-member law firm from New York City. I was at the time a solo practitioner. I walk in the court with a disheveled notebook, and there'd be an army. I can't remember. I think the lowest I ever saw was a dozen lawyers, all shiny portfolios with their $400 pens, and we prevailed though. Judge Hurd, who sits out in New York, found for us, and it went up to the Second Circuit, and they wrote a wonderful, very detailed, about a 50-page opinion.
Wow.
That's been cited by my count over 350 times by other courts in the country, that said students cannot be required to support speech with which they disagree. And it was a landmark case for all the students here in the state of New York.
And that even today, then, that's an optional membership for SUNY students.
Yeah,
now.
It went from mandatory to you have the ability to opt in or opt out.
Right. How long, it's always curious for viewers to know, if you're involved in a federal case, from inception to finality, are the time frames similar, or is it all over the lot and it just depends?
It does depend, but generally the federal judges, the state courts hear the vast majority of cases, and a judge on our trial level can have thousands of cases on his or her docket. In federal court, much smaller, so they can move things at a much more rapid pace. The issues tend to be somewhat more complex, so after everything moves along, the judges tend to be more contemplative in their decisions. And so I would say in a normal, from filing to a decision by the trial court, probably 18 months to 2 years. I know that seems like a long time for a lot of people, but there are some cases, complex cases, that can take 5-6 years to resolve. Then for the appellate process, probably another year or two as well. For example, you talked about the redistricting case. That was filed in 2011. It's somewhat unusual that we went up to the Second Circuit once already. We're back down to the trial court. So now we're close to 3.5 years into this case.
I can't imagine developing the record, but the federal system is electronic now. Is that correct?
Yes. It's I remember when they first went to electronic, and I was like, oh, this is the worst thing ever. But it really is tremendous. You're not exchanging paper. Everything is, you email it, and for lack of a better word, you just file it on the internet. It goes to the court. Then the court electronically serves all the party. You don't have to mail things. You don't have to paper things. And for some of the time, for the dilatory attorneys, maybe me on occasion, under normal practice, if I've got to file something with the court, 5 o'clock is when the clerk's office closes, or 4:30. You have to midnight, so there's an extra 7-hour grace period. And there was one case where I filed at 11:59, so on occasion I've had that 7-hour grace period work to my advantage.
Have you found in the federal system, and I ask this because I'm interested in trying to get some video into the arraignment process here in the town court and connectivity between the correctional facility and the town court, but have you found that the federal system also uses electronics for appearances?
Yes, and it's tremendous. Now, when we talk about the Northern District of New York, they've got understanding ranges all the way from the Canadian border out to Syracuse, and so we're geographically complex, and so to save money, and I think in a really wonderful way, is the federal courts allow the prisoners to appear by video, and I find it effective. I think the judges find it effective, and it allows certainly the court system, and therefore the taxpayers, to be relieved of what are normally just, not always, but probably normally pro forma appearances, right? As you know,
Right.
Judge.
That's right.
When someone first comes to court, the thing that really happens is you advise them of their rights, which may take a minute, maybe a minute and a half, depending how you read it, and then you ask them if they plead guilty or not guilty, and then they're back on their way to wherever they're incarcerated, and the amount of manpower it takes to have everyone come to the court to bring the prisoners to and fro in the area, in a day and age where, in an electronic society where, I have a kid in college. I don't pick up the phone. I don't,
Right.
we get on the computer and we Skype with them. I mean, this is,
Exactly.
we are living in an age that the justice system, and by the way, I'm glad there are judges like you out there where we should take advantage of technology. I mean, it's there waiting for us, and I think lawyers are always adverse, a little stodgy, a little hesitant to change things, but, things like video arraignment and video appearances, there couldn't be a better use of those resources than in the justice system.
Well, under my proposal, it's primarily focused on the rights of the defendant. If you're arrested at 3 in the morning and you're brought over to the Albany County Correctional Facility in a holding pattern, do you want at 9 o'clock to have access to a judge to have bail considered at 9 o'clock on video? Or do you want to wait until a bus is driven and maybe you're presented to that judge 8 hours later, because that's as fast as you can personally be taken there, so that the judge can consider bail? Yeah. I believe the defendant is better off with access to proper justice at those initial stages by having an access to a judge immediately at 9 in the morning as opposed to waiting to be carted around. And secondarily, of course, the costs, as you've mentioned, of having to have the sheriff incurs in bringing them to all of the local courts in this county, and then the safety concerns for those who are in the bus being transferred and to the citizens in general. Is there a reason why we're taking 20 people out of the correctional facility and all the effort that it takes to do that, to prepare them and then to receive them back? And it seems to be a very expensive proposition as well. And I dare say that I would believe the focus on the defendant's rights is paramount, and they're being denied that access by not, in my opinion, by not joining in many ways with these efforts that the sheriff and I have been very interested in moving this forward, even at a trial basis, a pilot program between the correctional facility and the town of Colonie Court. And we've even created the connectivity. We've already shown that we are connected now electronically. But there still seems to be some concerns by some that it shouldn't work. But I believe that it's the right way to go, and that those appearances for bail or preliminary hearings being waived in exchange for bail, that can be done right out of the gate each day, rather than waiting. Sometimes you're waiting for your preliminary hearing for 6 days. In the Albany County Correctional Facility, a defendant can be held without bail under New York state law right now. And when they come to my court, the first thing they do is they waive their hearing for bail. If I could give them bail day one, why the whole system benefits?
Yes, I mean, I think this is a program, we represent Sheriff Apple. I know he's worked with Colonie and you on
Yes,
this.
that's correct.
And I just think it's, look, I certainly as the county attorney think first of my deputies and the cost and the effort, but in a real sense, I think you struck the right chord. Right? These are people's lives that are being affected.
Yeah.
And sometimes we might forget the difference between sitting in the jail several hours as opposed to several days. And we possess the ability to correct that. And by the way, correct it in a manner that's efficient and fair.
Right.
And I just, I mean, again, lawyers, for whatever reason, tend to be risk adverse. Oh, we've always done it like this, and we can't anymore. I mean, the federal courts have done it. They've done it successfully. They've done it in a way that has helped not only the government, but has helped, as you point out, the individual defendants, and it's tremendous.
Well,
and so the county, by the way, is very, I know, very supportive of your initiative.
That's because of the enlightenment that you've brought down to Albany County government as well in a variety of capacities, and currently now as the Albany County Attorney. And the citizens are very pleased here in the town of Colonie to have you as our guest today and to share just a little bit about the wide range of impact that Tom Marcelle has made on not only Albany County, but the capital region and the state of New York, and nationally with decisions that have been rendered from the Supreme Court of the United States based on your efforts. And thank you for joining us today, Tom.
Thank you, Judge, for having me. It was a pleasure. This was great.
We're thrilled. I'm Colonie Town Judge Peter Crummey, and thank you for joining me on Benchmark.